Welcome to part 6 of the Contracts Exam Crash Course. For your final exam, remember you can go to www.lawbarcoach.com for more information, schedule a tutoring session. Now we're turning to the Doctrine of Mistake and how that might make a contract voidable. The idea here is if the contract was premised on what turns out to be a legally acceptable mistake, according to the definitions and explanations we're going to discuss, then the contract is voidable. The traditional definition is that a mistake is something that a mistake is held by both parties, that it relates to the subject matter of the contract, and that it has a material effect on the value of the contract. Imagine that I contract to sell you a 1959 Gibson Les Paul. We both think that it's a Gibson 1959 Les Paul, and it turns out that it's actually a reissue model that is worth only a fraction of the cost. Now, we say it's voidable because theoretically after the sale, the person says, no, I want to keep it. It turns out that this reissue model is very highly sought after. Only one of them are made. I want to keep it. That's fine. It's only voidable. The modern definition is very similar. It's a mistake held by both parties. But now we talk about a basic assumption and has a material effect on the agreed exchange of performances. The focus is not necessarily on the value anymore. It's on what was a basic assumption when the contract was made. Did both parties believe it to be one thing and then it turned out to be another, and that has a material effect on the actual contract itself? If I sold you that 1959 Gibson Les Paul and I told you that it had 10 gauge strings on it, but it turns out that it was only 9 gauge strings, that's not a basic assumption, and it doesn't have a material effect on the agreed exchange of performances. A key concept of mistake is that in order for a court to recognize a mistake, which justifies making the contract voidable, the mistake has to be something that the risk of that mistake was not borne by any of the parties, meaning that no party bore the risk of the mistake occurring. What does this mean? There's always a chance that a mistake might happen. For instance, if I sold the guitar and told the buyer that I believe it's a 1959 Gibson Les Paul, but I'm not certain, I'm no expert, I might be wrong, I want to warn you of that. I've now essentially allocated that a risk by agreement. The buyer can do one of two things. He can hire an expert to come in and examine the guitar, or he can ask that we decrease the price to reflect that risk. Now, let's say, for instance, a Gibson guitar is worth $100,000, and that 1 out of 10 of them are actually forgeries or mistakes or whatever. Now, if I'm selling 10 of them to him, he might say, all right, let's decrease the value of each one of these by 10%. So I want them for $90,000 each. That way, the risk of that mistake occurring is reflected in the contract price. If one of them turns out to be a forgery, which chances are one of them will, 1 out of 10 are, I've paid for that risk because each one of the prices of the guitars were decreased by 10%. And in order to bear the risk of a mistake, someone has to be aware of limited knowledge, but treat it as sufficient on the matter. So just like I was stating, I tell someone, the buyer, that I'm not entirely certain if this is a Gibson 1959 Les Paul. The person says, well, it is what it is. That's a risk I'm willing to take. Whether or not he says that or not, it's implied. If I tell him that, he can do one of two things. He can either take the risk, renegotiate with me, or hire an expert. But imagine that the two of us jointly paid for a third-party expert to examine the guitar. The expert comes in and says, yep, it's a 1959 Gibson Les Paul. We no longer have limited knowledge. We've hired an expert. But if it turns out that it actually was a forgery, then there's a mistake. Nobody bore the risk of that mistake. Nobody went ahead despite limited knowledge. And this is sort of the catch-all. A court can interpret a set of facts and find out who should have bared the risk of the mistake, judging by what was reasonable in the circumstances. Risk allocation has a couple of functions. We want the person who is the least cost avoider to bear the risk. That is sort of the default. So when we're saying about reasonable under the circumstances, we want the person who is in a position to minimize that risk from happening to be the person who bears that cost. Why? If you bear the cost of a risk, you're going to do something to minimize the risk. If you bear the cost of, if that Gibson guitar turns out to be a fake, and you bear the cost of that, you're probably going to be in a position to minimize that from happening. You'll hire the expert. Or if you are an expert or you have access to an expert, you're a least cost avoider. You can easily get that expert. We want you to do that because it's more efficient for a party. It's more efficient overall for the party who can do something for the least cost to do that. An example would be if a band was performing a concert and who would be responsible, either the band or the venue, for minimizing the risk of a fire happening? Well, the band would have to go and buy insurance for a property they didn't own. They'd have to call an insurance company. They're not familiar with that. That's going to be high cost to them. Whereas the concert venue, they know how to buy insurance. They probably already have other types of insurance. It's very easy for them to avoid the risk of a fire for the least cost. We also talk about conscious ignorance, that we don't want parties to be consciously ignorant of something that might affect the contract. So if I'm the seller of guitars, I've done, it's different if we're talking about merchants and whatnot, but imagine that I'm not a merchant, but I frequently sell guitars. The court wouldn't like if I was consciously ignorant. I never had my guitars appraised. I never bought a book to examine certain indications of forgeries, but I'm selling them anyway. That's conscious ignorance. That's not good because it makes contracts less reliable if it turns out contracts have mistakes that make them voidable. Overall, courts would rather not have to make a contract void or voidable. We'd rather tell one of the parties, sorry, you bore the risk of that happening. So far, we've talked about mistake as though they're both parties, two parties having a mutual mistake. But what if it's a unilateral mistake? What if I knew full well that what I was selling was not a 1959 Gibson Les Paul, it was a reissue from 2013 that's worth a fraction of the cost? They look the same, they're reissued, they're designed to look like the real thing, but it's not. Someone comes into my shop, they're unaware of that. They want the same guitar that Jimmy Page owns, and they make me an offer for $150,000 on a guitar that I know is probably worth $4,000, $5,000. So one party is aware of a certain truth and the other is not. I'm aware that it's a reissue. The buyer is not aware that it's a reissue. What happens? Can I take advantage of that person? Well, this is a tough situation because we like speculation. We like people to learn things, then make investments on them, and act upon that. So imagine if I go to a garage sale, I know a lot about fine art, and I buy things that I know that I can sell for much more money on other markets. That's a good thing for the economy if we can take stuff out of garages and put them in other markets to generate wealth and move resources. If it was stuck in the garage, that never would happen. But that's not bad faith. Someone wants to clear out their garage, they put things for sale, and I'm using my expertise to buy. It's different if someone were to come into my guitar shop and be under a terrible misimpression, and I'm taking advantage of that. That's the difference here, is that it requires bad faith, that it's unconscionable. Now, so let's compare the example of the guitar sale and the example of the garage sale. In the garage sale, if I never went there, I'm an art expert, but I never went to this garage sale, nobody would have been any the wiser. It would have been sold for very little to someone else, and everybody's okay. However, I show up, I'm an expert, I spot things that are very highly valued, and I purchase them to go sell them elsewhere. That's not really bad faith. Compared to if I'm the guitar shop owner, I know full well that someone's under this misimpression. I take advantage of it because I never correct them. I never tell them, pal, you're actually paying a fraction of what this should. You're actually paying, the opposite. You're actually paying, 15 times more than this thing is worth. I'm taking advantage of that. He's going to get home and he's going to realize at some point in life, if some friend comes over, looks at a guitar and says, that's actually a reissue. You got screwed. That's bad faith. That's unconscionable. So it doesn't necessarily, not every contract that has an imbalance of what something is worth necessarily means that there's bad faith. The Peerless Case. This is an example of a mistake, and it's also an example of meeting of the minds, which we've talked about earlier. So here it's actually void. This is just sort of a thought experiment. It's not necessarily the way a case would come out in a court today, but this is a way of thinking about the different issues. And when a mistake not only is a mistake, but it's actually a failure of the meeting of the minds. So in that instance, there were two ships with the same name, the Peerless. There was a contract for the goods that arrived on the Peerless. That's from Bombay. And one party thought that it was the October ship, a ship named Peerless that was arriving in October. That was what the buyer wanted. He wanted his stuff in October. The seller thought they were talking about a ship that was arriving in December. Two ships named the Peerless, one arriving in October, one arriving in December. So there's a couple of different ways this case could have come out. On the one hand, the judge could have said, all right, well, I'm going to say that Peerless means the December Peerless. I'm going to say that the Peerless means the October Peerless. I'm going to say that either ships are fine. Or, and this is what the court actually did rule, that the parties never made an agreement because they were each thinking about two different ships. There was no meeting of the minds. And because they never made an agreement via the meeting of the minds, there was no agreement or contract in the first place. This is void. It's not voidable, it is void. There is no contract. An agreement was never made. So what are the remedies upon a mistake? If a court rules, in fact, there is a mistake and we're going to recognize it, there's two things that can occur, either or. Rescission, the duties to perform on the contract are extinguished. They say there's been a mistake, everything is over. If we contracted to sell that 1959 Gibson Les Paul, it turns out it was an Epiphone, the court would say You don't have to hand the guitar over, and you don't have to pay for it. All bets are off. Restitution returns parties to the way they started, which is called the status quo ex ante. This is that Latin word again that we've stated ex ante beforehand. So let's say I handed the guitar over, that guitar is going to come back to me. Or if it's a contract where I started to perform some type of work, I would be compensated the value of the work that I conferred. Just the idea here is there was a mistake. We're canceling the contract through rescission. Let's get everybody back to where they started from. So we talked about mistake, and now we're going to talk about impossibility. A mistake is when the parties held something to be true, and it turns out it was not true. Impossibility is when something actually, after the fact, renders the performance of the contract either impossible or impractical. This is a very rare occurrence, the idea being, like we discussed above, that there's risk allocation, that one of the parties should have bought insurance, they should have known that something might prevent them and they could have invested in an alternative, something like that. An example is if I contract to build a house for you and the bridge that goes to your property was destroyed in a storm, and now there's going to be a very, very long route through the back roads and the woods and mud to get to your house. And I say, well, it's impractical now. I can't bring my stuff in that way. The court might say, and this is all argument. There's nothing really concrete about this. It's all about making arguments. A court might say, in that instance, you're a builder. You know that you have to get items to a place that isn't developed. You should have been aware that there was only one road and either bought insurance or looked into ways to get things through the woods or the secondary way, meaning that's not our fault. That's your fault. You specialize in getting materials, building materials from point A to point B. You need to bear that risk. There was only one road. What if that road went away? You needed to be aware of that. So that's why it's rare, because generally speaking, one of the parties will bear the risk. So it's impossible, but it's also impossibility. True impossibility is if something is completely destroyed or someone dies. If I make a contract so Peter can give me guitar lessons and then Peter dies, it's impossible for Peter to give me guitar lessons. But most often things are simply impractical. An example is if I made a contract in, let's say, 1939 that I would go into Germany and give guitar lessons to somebody who lives in Germany. And I would give them the lessons in 1945. 1945 comes around, we're in World War II. Is it impossible for me to get to Germany? Well, there's a war going on, but theoretically I can sneak behind enemy lines, parachute in, but the reality is that it's impractical. It's not impossible. That's why this concept is really stated as impracticality. Because if we only talked about impossibility, it would almost never, besides death or destruction, it would almost never occur. But just because we're talking about impracticality, it's still rare. It's a very high threshold of impracticality. So not only is it a high threshold of impracticality, but you also need to determine if one of the parties bears the risk. So in that example of the guitar lessons, if we discussed in the contract that we were aware of European developments in European international relations, and that we were making the contract in spite of that, maybe one of the parties did bear that risk. So here are the requirements of impossibility. A party's performance is made impracticable by something that is not his fault So you can't blow up the bridge that allows you to build the house, to get materials to build someone's house, and say, well, now it'd be impractical for me to go through with it. That was your fault. And again, it has to be a basic assumption of the contract. It can't be something that is minor or a small part of the contract. We're talking about something that is a basic assumption. And when we say basic assumption, it's like assuming the bridge will be there because we need the bridge there to get materials, or that there won't be a war going on with Germany and that you'll be able to get into Germany. That's just something that you assume when you're making the contract. I'm assuming we're not going to be at war. I'm assuming that it will be possible to get materials over using a bridge. So a way of thinking of that is it's not within the realm of practicality in the universe as envisioned by the contract. Wow, what does that mean? The realm of practicality in the universe as envisioned by the contract. So the example of the guitar lessons in Germany, my universe, when we made the contract, was that the United States was not at war with Germany. So it's very practical to get to Germany. But then the universe changes and it becomes very impractical to get to Germany because that was not something envisioned by the contract. But it might have been. So if like I said, in the contract, if we stated that we made this contract despite the realities of international relations and the Third Reich, whatever, then that was envisioned by the contract. Or, like I said above, a judge might say, in the example of the house builder, that you have to envision that bridges fall down. And if there's just one bridge connecting the property to a main road, that's something that you should have been aware of. You can't say now that it was not envisioned by the contract and that it wasn't not in the realm of practicality. Here are some examples. An act of government, like I was stating, they go to war. Destruction of the contract, subject matter, death of a person. These are very significant and serious things. A temporary impracticality is if performance is now suspended, the practicality of performing is suspended but for a limited amount of time. So in the example of the guitar lessons in Germany, if I could somehow get the person on the phone and we figured out that the lessons, there was no pressing need to have them that year, we can do them the next year. Well, looks like we're going to win the war with Germany. That impracticality will be lifted at a certain point of time. It's only temporary. A court might allow performance to be suspended for a certain amount of time without deeming it a breach of contract. Meaning this: if I didn't show up to give the lessons, that's a breach of contract, right? But a court might say it's not a breach because it's currently impossible. Once that impossibility is lifted, then you can perform, and as long as you do it at that time, you will not be in breach of the contract. Now, again, we're talking about very significant things here. Act of government destruction. One example, and I mentioned this earlier in another context, was a delivery of materials that was going to be made through the Suez Canal in Egypt that was closed due to an act of government. And they now had to go all the way around Africa to deliver it, and they said this made it impractical. It made it impossible. But it's not impossible. You can indeed go around Africa to deliver it. So the question there is, does that rise to the level of impracticality? And that's what you ultimately need to argue, is that something was so unforeseen, such a basic assumption, that it makes it impractical. So if the delivery was from the Middle East to Japan or California, something that is incredibly far away, well, that's only a diversion. But if the delivery was to two people who were just 20 miles apart, but they still had to go through the canal to get there, and now instead of going 20 miles, the ship has to go 2,500 miles, well, that might rise to the level of true legal impracticality. Another concept within impossibility is the frustration of purpose. It's not that it's become impossible and practical, or that there was a mistake regarding the truth of a fact related to the contract, but that now, after the fact, things have really significantly changed. An example is if I made a deal to pay somebody in bitcoins, and I made that deal in 2011 or 2012, and now the value of a bitcoin has gone up 1,000,000% or whatever it is. I thought I was paying you dollars, but now I'm paying you in units of thousands of dollars. The contract to me has become worthless. And it was a fact I was unaware of. I had no idea that bitcoins would rise that much. I might have understood that they would go by a certain amount, but that currencies never go up that much in 2 years. And it was a basic assumption of the contract that I would be paying you commensurate with the market value of your services, that I didn't want to pay you 1,000 times more than what someone else could have made. This is controversial. The Bitcoin's example is obviously very extreme. It totally frustrated the purpose of this contract. I'm going to be out of business. I'm probably going to make one payment to you and lose all my money. But it arises oftentimes when companies, the value of the contract is designed to match some type of market indicator. So if I'm selling gas to an airline, we might state that the price of the gas will follow a certain index that's published. That way, 5 years from now, the price that we're paying on the contract will be fair. But sometimes those indexes do crazy things, and now all of a sudden, either you're getting gas for free, or you're paying some ridiculous amount. But the argument that you'd make on an exam is what was the basic assumptions of the contract, and was this something you're truly unaware of? We know that market indexes there's a natural ebb and flow. That's a risk that you take. But in the instance of the bitcoins, that is something that was totally unforeseen, totally out of the realm of possibility. Nobody could have been aware of that. Anticipatory breach, so we're moving right along now, is when a breach occurs before the time of performance is due. Normally, breach only can occur when performance is due. If I contract to wash your car on Tuesday, you can't sue me for breach on Monday. Why? Because I haven't even, my duty to perform hasn't matured yet. It's not until Tuesday. After Tuesday ends, we'll see if I wash the car or not. And after that time, you can sue me for breach. The problem is when things are in the future and it looks like someone might not follow through. Let's say a NFL stadium hires my company to provide security for them. We make the contract in January. Beginning of NFL season is, the first game is in August, preseason, or September, first regular season game. So the breach, a potential breach, can't occur until the beginning of the season. That's when performance is due. Will my guys show up to provide security or not? But an NFL stadium would be terribly screwed if, come game day, there's nobody for security shows up, because they can't call anybody, or if they did, they'd be paying astronomical amounts. So imagine my security company is been having some difficulties, labor problems and whatnot, and things look dicey. The NFL stadium thinks to themselves, well, if we know they're not going to follow through, we'd rather know that now, and we can take measures to hire somebody else. That's what anticipatory breach is. It allows for a remedy earlier than the time of performance if things arise to make it appear as though there will be a breach. But it's not always that easy. You can't just look at someone and say, I don't think he's going to fall through. I want out of this. Because then it would be too easy to get out of a contract. Remember, contracts are designed to be reliable. Courts will always err on making a contract reliable and keeping a contract and not voiding it or canceling it. There must be clear and unequivocal language or acts that suggest a repudiation of agreement. If half of my security guys, I had to let them go because of declining revenue, and I haven't made a move to hire anybody new, that might suggest a repudiation, and it's an act. Or if the stadium calls me up and I say to them, I highly doubt we're actually going to be able to do it come game day. That's pretty clear and unequivocal language. But that's where you're going to be arguing. That's where the debate is. If I simply tell the NFL stadium, it's going to be difficult, but I believe in my company, I think we can do it. Is that clear and unequivocal? Well, it's balancing. There are instances where if I don't perform, the other person can cover. After then they say, okay, I'll hire somebody else, or I'll buy another thing. But in a situation like this, if I don't show up to provide security, that NFL stadium is screwed. So you're balancing it against the harshness of what happens. You have a couple options if you're the non-breaching party. You can urge performance or urge retraction. You're the NFL stadium and you say, listen, hire people. Show me that you're willing to do this. Or retract your statements that you don't think you can do it. The example of the NFL stadium doesn't have this, but you might suspend your own performance. If I contract, I'm going to build a house for you. In return, you're going to give tutoring lessons to my son in math. And it looks like I'm not going to be able to build that house. And I've made statements to that effect. You might stop tutoring, both because you don't want to have to do something and then not get anything in return, and because that will also, through an act, help urge me into performance. Or you can end the contract or sue. And you're suing for anticipatory breach at that time. That's the cause of action for anticipatory breach. You go to court, you sue, and go to court and say, there were clear and unequivocal language or acts that suggested a repudiation of the agreement. I want you to declare that this person is in anticipatory breach, and as a result, I'm going to have to hire another security company, and they're going to have to pay me the difference. The UCC, Section 2609. It's otherwise the same as this situation, except a party can take it upon themselves to communicate to see if there's a problem. With the common law, you're kind of waiting to see if there were any clear or unequivocal language or acts. The security company fires half of their security guards, or they say something that they're not going to perform. But you can't just out of the blue call them up and be like, promise me you're going to perform. They already did. They made a contract. But in the UCC Section 2609, if a party has any reasonable grounds for insecurity via a writing, they may demand adequate assurance. And what is the purpose of this? It allows you to suspend your performance in the meantime. So, if you have reasonable grounds for insecurity, you send that letter, you suspend your performance while you're waiting, and if they never get back to you, then you've suspended your performance, and you move on. Or you can sue for anticipatory breach, or they get back to you and they say, oh no, we're coming through with it, we're good to go. And then you have to start performing again. Warranties. A warranty is a promise regarding the quality of goods or services, and it may be express or implied. The opposite of a warranty is disclaiming a warranty or expressly stating that it's being sold as is. You can do that with a good. It's harder to do that with a service. You really can't say to somebody, I'm performing a service as is, because, well, That really is illogical. That sort of applies mostly for goods. I have a guitar in my back of my guitar shop. I haven't even plugged it into an amp yet. It is what it is. It's a nice, looks like a nice piece of wood. Color's nice. It has strings on it. The frets. It appears to have electronics, but I haven't tested it out. I'm selling it as is. It may or may not work. And you take that into account when you purchase it. You might get lucky and you have a beautifully working guitar, or you might have to put some money into it to fix it. And that is reflected in the price. If I have a $1,000 guitar that otherwise would be $1,000, but I'm selling it as is, you might only buy it for $500. The idea being, if it actually doesn't work, you now have some room to spend money to buy new pickups or pots or caps or whatever you need to get it working. A warranty of merchantability. UCC section 2314 has an implied warranty that goods are merchantable if the seller is a merchant with respect to goods of that kind. If you go into Guitar Center to purchase a guitar and you take it off the wall, it looks good, you buy it, it's implied that when you go home it's going to be a working guitar, that it's going to do things that guitars are supposed to do. You can't use it as a doorstop and then it breaks and you bring it back and say, well, I was using it and it broke. No, well, it's merchantable respect to goods of that kind. I'm sorry, it's merchantable regarding to the type of good that it is, meaning it passes without objection in the trade. So how does a guitar pass without objection? It can play. And it doesn't have problems with volume or tone or something. It does what it's supposed to do. There obviously, especially with guitars, you might get a gem. Oh, this guitar plays beautifully. The controls on it, I can roll off the volume and the tone. I got a gem. Doesn't have to be a gem. It just needs to pass without objection in the trade. If you're selling a $2,000 guitar, it should do what a $2,000 guitar is expected to do. If you sell a $200 guitar, it should do what a $200 guitar is expected to do. If it's a fungible good, it has to be fair, average quality as described. So if you're buying widgets, the box of widgets, all of the widgets should be in good quality as described. Fit for ordinary purposes of that good. That's what I was saying above. You can't just bring a guitar home and then use it as a doorstop or something strange. It should play music. And there must be adequately contained. It must be adequately contained or packaged and conform to affirmations on labeling. This essentially, when you go to a store and they say we don't have a return policy, well, that's all well and good, but too bad. You had an implied warranty that goods are merchantable. Fine, then I'm not selling it. Then you have to pay me the value. It doesn't matter what we call it, a return or whatnot. You had an implied warranty that this would be merchantable. It wasn't. Fitness for a particular purpose. This is similar, but it rises above just general merchantability. According to UCC section 2315, if a seller has a reason to know of the buyer's particular purposes of using the goods and that the buyer is relying on seller's skill and judgment, there is an implied warranty that the goods will be fit for that purpose. So the seller knows of the buyer's purpose, the buyer relies on the seller. That means there's an implied warranty that the goods are fit for that purpose. If I'm purchasing a off-road vehicle from a dealership, that off-road vehicle must be merchantable. It must be able to do what off-road vehicles can do. I can take it on grass or dirt or sand, and it will be able to run and work properly. It will pass without objection in the trade. But what if I tell the merchant, I work for Bear Grylls, the adventurer, his television show. He's going to be doing some sort of adventure in the middle of the desert and then up into mountains and be using them at extremely high elevations. Will this off-road vehicle work under those conditions? I'm not an expert in off-road vehicles. I'm the producer of his show. All I know is I need a vehicle that can do this. I'm not in a position to hire some sort of off-road expert. That's why I came here. You're a seller. You know about this stuff. I'm relying on your skill and judgment. If the seller knows about that purpose and I'm relying on it, there's an implied warranty that it'll be good for that purpose. If I never told the seller about that, we bring it to the top of Mount Everest for a month and it stops working, I can't say that it wasn't merchantable. Why? Because no one is saying that these vehicles can be used in extreme conditions. But if I told the merchant about that and I relied on it, he knew about it, I can bring an action that it was not fit for a particular purpose. Opting out of the warranties. The UCC is the default. You can disclaim any of these warranties. Just like I said, I can disclaim the warranty of merchantability for guitar by saying, oh, this is sold as is. That's very common for used items. Oftentimes, the distributor won't allow a dealer to do that. So if Gibson, for instance, all of their guitars are sold at dealerships like Sam Ash or Guitar Center, those are sold with warranties. No one's opting out. They might even have a better warranty than the UCC allows for. The idea is that the Gibson doesn't want their customers to feel like they ever got screwed over, right? But if it's being sold on eBay or Craigslist or some other market, the person can be like, listen, I don't want to have to worry about this, somebody coming back to me. You can disclaim that, the warranty. But it must be made by conspicuous language. So if I go to Guitar Center, I can't get home and then read on page 19 of some obscure agreement that I signed that it said that they disclaimed these warranties. There needs to be a sign maybe on the guitar that says as is, used, poor condition, used condition, whatever the case is. And that needs to be, the conspicuous language could either be said to me on the guitar, in the contract, or whatever. I have to be aware of that. That's what that is.